What's going on, IP family? We are back with another live, but it's actually pre-recorded. I am your host, Dave, 10-year intellectual property attorney, dealing with everything from patents, trademarks, copyrights, trade secrets. And we got a little bit of everything going on here today with regard to patents, copyrights, and trademarks. Some housekeeping items. First, hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community to the extent that you're not a part of the community, as well as, again, the ebook just dropped. Got IP. They're snatching it up fast. That link is in the description. Essentially, if you want to know how to kind of get an ideal all the way up to monetizing that ideal of the product, it talks about that in every step in the process. The good thing about it is we have a lot of stories in that ebook, or I have a lot of stories in that ebook that kind of based on Shark Tank businesses, based on interviews that I've done with many of those businesses who've been on Shark Tank, just kind of really hammering home the story or the principle that I'm trying to teach. So definitely go check that out. That link is in the description. Typically, I'll do this live on Sundays. This coming up Sunday, I'll be traveling. So by the time this comes out, I will be on an airplane coming back home from out of the state, and I'm actually trying to join in the chat when I premiere it, just to kind of see what's going on. So definitely check it out, and I'll be back the following week, Sunday. I'll be back live with you all, and definitely looking forward to that. Is that all I have? We're gonna start with the interview of the week. Rinse-a-roo. It's a Shark Tank business. Speaking of Shark Tank, I typically do these. My Shark Tank pitch of the week. And this was the actual last episode of Shark Tank of season 16, episode 20. I'll be doing that next week since, at the time of me recording this video, the Shark Tank episode is not out yet. So I'll be doing that pitch. I'll add that on to the live next week as far as the Shark Tank pitch of the week based on my opinion. But the business that we're talking about, Rinse-a-roo, it is essentially a dog wash station, a human wash station, that you can kind of connect to your bathroom. You don't have to use a bucket anymore. And that interview just came out on Wednesday. A dynamic duo, the mom and the son. I love, man, when you keep it as a family business, and a mom and a son started the business. They're killing it. And I was able to kind of, have them interview them over the coming week. They did get a deal with Lori on Shark Tank. Not only did they get a deal with Lori, they were the golden ticket winner, which essentially means Lori gave them exactly what they were asking for. She didn't try to negotiate. She loved the product. She loved kind of how they built the business. And again, they did build a business making millions of dollars based off their Rinse-a-roo product. And again, they got to deal with Lori for exactly what it was that they're at or was asking for. So shouts out to Jake and Lisa on that as I pull it up here. We're going to kind of play a little bit, and then I kind of give you my thoughts as I typically do on these pitches. So let's go. Let me put on my headphones and see what they're talking about. Let's go here. You didn't have the knockoff situations where once you get to that $4 or $5 million mark, it seems like you have these kind of Chinese knockoffs flooding the market. So I guess how do you guys kind of square that?
Yeah, well, thankfully, we have IP, we have, copyright, we're doing takedowns on Amazon for patent infringement with the Apex program.
Yep.
I'm hoping that the silver lining of the tariffs is that a lot of these Chinese sellers that are always competing with us just go away. They're always undercutting the brands. They don't necessarily use our brand name, but they figured out how to create a knockoff that doesn't use our images, and it hurts the American sellers. And
a snippet of that interview. Actually, that interview has been well received. A lot of people have been watching that. So go check out the full interview on the channel. Jake as well as Lisa, the mom and son dynamic duo. And on that, she's talking about how they kind of essentially handle the knockoff situation. So as I put it, hey man, especially when you're selling on these e-commerce platforms, Amazon, whatever the case may be, once you hit that $4 or $5 million mark that you're generated in revenue, it's like clockwork. The Chinese knockoffs come flooding the market. And she talked about copyrights, which is an important thing because you got to look at this intellectual property as different tools in a toolbox, as I like to explain it, where you have your copyrights, you have your trademarks, you have your patents, and kind of based on what somebody is doing, you can pull out the appropriate tool to handle them or deal with that person. So if somebody's taking your images, then you can hit them with a copyright lawsuit. If somebody's taking your exact name, the rinse-a-roo in that case, you can hit them with a trademark lawsuit. If somebody is infringing the patent or the product, you can hit them with a patent infringement lawsuit. Obviously, copyright infringement and trademark infringement is going to be the easier options or the less expensive options to deal with somebody. And the patent infringement, you kind of want to leave it as your last option or your last resort, just because it does cost, a little bit of money, even with the Apex program on Amazon, to get products taken down. Obviously, you have to do what you have to do if it comes down to that. But you want to look at this IP as different tools in a toolbox. You don't want to be trying to cut a paper and pull out the chainsaw. No, you want to take some scissors out and be able to cut it. So you got to, and this is having a good IP attorney help you strategize or get things in order with that. So I thought they gave some great tips. And then what they said about the tariffs, I know that interview was recorded prior to the deal or the pause with the tariffs with China. And hopefully, again, Donald Trump, he's able to negotiate somehow them stopping the knockoff situations and the IP theft. And if he can do that, that is going to be a boom for U.S. businesses, for businesses selling in the U.S., and to be able to kind of make profits, make millions of dollars, change their family's trajectory of their life, and not have to worry about the knockoffs. That's going to be big. So let me know your guys' thoughts on that. Let's move on to the next subject. Your boy Trump. Hey, man, Trump is not shy about firing somebody if they are not doing a good job. So Trump, again, talking about moving on to copyright here, as we see, as I pull up the Guardian article, Trump reportedly fires the head of the U.S. Copyright Office after the release of the AI report. So I guess one of the first things, and again, I did maybe a fuller breakdown. It was like 10, 12 minutes. Go check out that video that I did on the full breakdown. This is kind of more of a quick hits, a weekly recap, if you will. And typically, people don't know this, but IP law is a federal thing. I mean, you have some state trademark stuff, but patents and copyright, that is a federal thing. You have some, I guess you do have some state trade secret stuff as well, but for the most part, IP is handled at the federal level. Number one, because they are more equipped with the personnel to be able to examine applications and deal with infringement compared to at the state level. But then, more importantly, this is in the U.S. Constitution. Article 1, Section 8, Clause 8 is the IP clause, which essentially says to promote progress in science, to promote the progress of useful arts and science by giving exclusive ownership for a limited time to authors for their writings and inventors for their discovery. So this has roots in the Constitution, which brings it under federal jurisdiction. But it seems like in this case, Trump, from what I can tell from reading the article, and I'm not going to read the article here. Go check out the video where we actually go through the Guardian article. It seems like you had this AI report, and I've been talking about this for a while, and I've been keeping you guys up on what's happening as this AI landscape comes about. Typically, with AI and these, you have either the algorithm, which a lot of times can be protected via a patent, or you have the data. You have the AI models, the algorithm, the AI models, or you have the data. Now, typically, the data is protectable via copyrights, whether it's books, whether it's songs, things of that sort. And the big companies, the Facebook, the Teslas, they have AI models. But you need to train the AI models for it to be good, for it to work, for it to provide value. And a lot of times, they don't have the copyright or the data to train an AI model. So what do? They use data that's out there. But a lot of times that data that's out there is already copyrightable and protectable. Therefore, they can be committed, or they're a lot of times looked at as committing copyright infringement or IP infringement by taking that data without permission. That's the whole point of intellectual property, is that to get to the extent that you have created or invented something, you have protection on that. People have to get your permission to be able to use it. To the extent that they're not, that's considered IP infringement. You can sue them, get money, get them to stop using it. But in this AI case, it seems like amid all this controversy on whether or not these AI platforms and AI models can freely use this copyright data without any, essentially without getting slapped on a hand or the wrist with a lawsuit, seems like Trump is kind of more so pushing with this with this big tech. The Tim Cooks at Apple's, the what's your boy now, Elon Musk at Tesla, the Mark Zuckerberg at Facebook. He's essentially leaning towards them being able to train their AI models using this data, using this copyrighted data for the sole purpose of using this copyright data to train the AI model without having to get permission from the actual artist or the copyright owner. And it seems like the copyright office is kind of really protecting the copyright owner and saying, no, by them doing this, by these big tech companies doing this without getting permission, that's actually trade or IP infringement, whether it's, copyrights with the books and music. If they're using this data without getting permission from the owner of it, then that's copyright infringement or IP infringement. And that's kind of essentially what was in a report that had released. And it seems like Trump and, his team, the executive office didn't necessarily like that. So, hey, they chopped her. They fired her. So again, like I said, I know a lot of times you have to fire people in business as a result of them not performing well. And again, to the extent that you have to do that, I'm all cool with that. But it seems like this firing may not have been justified by Donald Trump. Seems like this is more so, hey, if you're not going to kind of see things the way I see it, I'm gonna fire you and get somebody else in here who sees it the way I see it. Which, again, I'm gonna always be a proponent of protecting the owner of the copyright and making sure that they are able to protect their infringement or their copyright without, or their IP without somebody infringing it willy-nilly. So I don't know how I feel about this one, man, because I understand that the AI models, those are important, but at the same time, man, you got to be able to protect the copyright, the owner of the copyright. Otherwise, I think, in my opinion, it can be a free-for-all, and really the big tech companies are at a big advantage and the small guys at a disadvantage. So let me know what you guys think as I move on to the next one, which is drug patents. Now, we talked about trademarks. Or we haven't talked about trademarks yet. We'll be talking about that next. We talked about copyrights. We talked about patents as it relates to Rinse-A-Roo and what they have going on. We're going to also go back to a form of patent, that being a drug patent. So let me just kind of lay the land before I pull up this video. And I want to hear about PBD, which I love his content. I actually just watched the video from his that interview that he did, but I think I disagree with him on this particular topic. So you have three types of patents. You have, which is not commonly talked about, a plant patent, and that lasts for 20 years. It protects asexually reproduction of plants. You have a design patent, which protects the ornamental use of things. I actually just filed a design patent for this pill bottle here a couple weeks ago, and it doesn't protect the function at all. The functionality, it just protects the look of it. And then you have a utility patent, which is the most common form of patents, and that protects the functionality of something. And the drug, pharmaceutical companies, they get patents on these drugs, and those fall within the utility realm, utility patent, which lasts for 20 years. So it seems like in this video that I'm gonna pull up where PBD is kind of talking and give his take, he's saying that, hey, drug companies, and I did a longer video, so definitely feel free to go check that out. Again, this is just a quick recap or a weekly recap. He's pretty much saying that, hey, these drug companies, they are, and I agree with him on a portion of it, but not with all of it. Hey, these drug companies, they're charging a ton of money for these drugs, and he's saying that the patent should not be good for 20 years. It should be for a lesser time, maybe 7 years, maybe 8 years, maybe 10 years, but it shouldn't be for 20 years, because by allowing the drug company to have this protection for 20 years, you kind of give them monopoly and allow them to charge these crazy prices that ultimately hurt the consumer. And then when that patent expires, number one, they can extend a patent, which is some BS. And then number two, to the extent that everything expires, then next thing you know, competitors come in the market, and what was once a $500 pill now is all of a sudden $50 or $10. So, which again, some of it is messed up. I do agree with that, but I don't think the solution is reducing the term of the patent. I'm going to give you my solution here in a second, but let me kind of pull it up to kind of give his take on it, and then, like I said, I'll kind of bring you guys back with my thoughts. Let's go. Oh, man, I'm about to play it without showing you. There we go. Let's go.
Bernie Sanders, all these people, all of these guys are bought and paid for. This is walking the walk. This is actually doing it and putting his money where his mouth is. And this is a great freaking.
Can I tell you something again? For me, this is great.
That's amazing.
But it's another quick fix. What we need to do is change the patent laws of Big Pharma.
Can he do that?
Yes, of course. Mm-hmm. Because the same way they extended it by lobbyists, you can shorten it.
And I do want to correct him. Trump cannot do that, you actually have Congress. Again, Congress makes the laws in the country. Now, again, we all know that Trump is doing these executive orders left and right, but you can't change the duration of the patent laws. Congress has to do that by legislation. So I do want to correct him on that, because Trump doesn't have the authority to change the duration of a patent. Only Congress has. Let's go.
All they need to do is shorten the lifespan of. You should have a patent. You should have a run rate.
Seems like he's at least
you should
4
have
patents.
some years where you have ahead of everything else. Pharmaceutical patents granted 20 years from the filing date, providing exclusive rights to manufacture, use, and sell a drug for that period. This exclusivity incentivizes innovation, but can also lead to higher drug prices. Beyond the 20-year patent, regulatory exclusive like orphan drug exclusive can further extend market protection. So not only do they do a 20-year, and then there is now a way to extend it for another 18 years, another 20 years. So then guess what? They can sell a drug that costs them $2 or 45 cents or $3 or $1.20. They can sell it for $800. They can sell it for $190. They can do that. And then the moment the patent expires, have you seen what happens to the prices when the patent expires?
All the way down to cents.
It drops in ways that nobody even can understand. So for me, it would be great for Bobby to work closely with the president to get working on the patent laws that Big Pharma has. If you reduce it,
again, the president does not have the authority to do that. That comes with Congress. Congress has to set that duration. You have the 1952 Patent Act. Actually, Congress extended design patents typically only last 14 years. They extended that to 15 years via legislation, but the president does not have the authority to do that. Congress has.
To 10 years, to 8 years, to 7 years. You know what that'll do? It'll dramatically drop the prices of health insurance. So what are we paying right now for health insurance? Tom, if we reduce, let's just kind of spitball here. What happens if we?
And I do want to say some of the things where I disagree with him at really quickly. Number one, and I was looking up on the internet, thank God for Google, it takes a drug company 10 to 12 years to actually recoup their money by way of research and development and having to get all this FDA approval. So that's why I said I disagree with the whole 7 to 8 years or 10 years, whatever the case may be, because it does not incentivize drug companies to put out inventions, a product that help people, because they're not going to recoup their money. I love the fact that you are getting 20 years. Now, I will say some things that can happen. Number one, and he talked about the whole evergreening concept, where when a drug is about to expire, they do a minor insignificant change the drug company does to extend or to get another patent for another 20 years, and therefore extending the run of the shelf life of the I guess invention or the drug. And I don't like that. I think Congress, as well as I think the president, can kind of help out with that. Whereas what they essentially would do is say, hey, USPTO, United States Patent and Trademark Office, this is how we're going to examine these drug patents. To the extent that the drug is about to expire, it has to be a significant change for them to get another patent on that drug. If it's insignificant, meaning that, hey, if you're taking a pill and next thing you know, you're taking a liquid of it, that's insignificant. We're not going to let you extend that drug patent as a result of that. And I think that will help out that evergreening concept, cut down on that evergreening concept where the drug companies can effectively extend the patents. Let me know if you agree with that. But the other thing too, and I think this will help out potentially with the price, is just cutting the red tape. Part of the reason why patents, the drug companies charge a lot and have to spend a lot of money on patents, I think it was like $2.5 billion to get a drug to market, is because the FDA lets them or requires them to jump through all these hoops, getting kind of regulatory approval. We all know what Trump is doing with the energy and kind of trying to cut the tape so that people can drill and we can have energy dominance. I think that's something that he can do with the FDA, which is, again, an executive office, a federal agency, to say, hey, man, we're not going to, again, it has to still be safe, but we're not going to require these drug companies to jump through all these hoops to try to get their drug to market. And hopefully as a result of that, the prices come down. Therefore, the consumers don't have to pay as much, and you can still give the 20-year lifespan, and the drug company can still make money, recoup their original R&D as well as make money. So those are my thoughts. Let me know if you agree with that or disagree with it in the comments or in the chat. I may be going back and forth with you guys, but let's finish up what PBD has to say about this and then kind of move on to the next subject. Yeah, let's go.
Reduce patent law from what it is 20 years.
I disagree with that.
How much do you think it'll reduce costs? Brandon, Tom, what do you think?
I disagree with that.
I think it would immediately reduce monthly health insurance premiums for Americans.
And the crazy thing about this is Pat is a business guy. So the fact that he's saying he's not even taking into an account research and development, at what point will the drug companies break even? So if it's 10 or 12 years is what essentially Google is saying, it doesn't make sense for 7 years because they're not going to make their money. And as a result of it, they're not going to create newer drugs that help people. So I disagree with it. I think 12 years is no. Again, if they're not making their money back into 10 or 12 years, it has to be 20 years. I think there's other things you can do to reduce that cost. But let's finish up.
By like 15%, and over time, probably a third. Wow. And I say that because you know what the drugs do. And I've gone through things with my daughters who needed particular drugs when they were very, very else that happens. If you every 10 years expire the patent, what happens is I got to run faster cadence. So maybe that's more medical research and more.
See, and this is what I'm saying. He's talking about running faster cadence, but you can't run faster cadence because of the USPTO. Hopefully you guys understand that he's saying, hey, just if you expire the drug, if you make the drug expired or, expired in 10 years as opposed to 20, then you have to go faster. But part of you have to get regulatory approved. This is not like you're doing something and you're manufacturing a widget and just putting it out there. You have to have the FDA, the Federal Drug Administration, sign off on what it is that you're doing. And we all know, if it's one thing we know about the federal government, they do not move fast. So hopefully if they can kind of cut down on the red tape and move fast, you can get the drug to market faster. And as a result of it, you can start making money faster and then cut down on your costs. So, but he's talking about this this expediting the process. You can't do that because you're dealing with a third party, and that third party moves extremely slow. Let's go.
More projects
Great.
running faster that helps good drugs
That's
get
right.
invented that help a lot of other things, number one. And also, it's not just that the price will go down for the average consumer on their health insurance. It will also go down for the federal government on Medicare. Because what is Medicare Part D? It's a special insurance you get. D stands for drugs. It's for if you have a condition, you have a thyroid condition or something, you have to take a special medication that's more expensive. It's not covered fully under Medicare. And they even lobby to make it so that they can't prescribe you the generics. So they're in the knickers of Medicare like that. And so now you would also make it so that maybe elderly people on Medicare, the U.S. tax dollars would go farther so they could get the thyroid drugs and things that they need. And they wouldn't be reaching into their pocket for Medicare Part D.
I love that, Tom. What a great breakdown.
So yeah, that's pretty much it. Like I said, I did a full breakdown of that. Go check that out. I just wanted to kind of give you my thoughts on that. Again, I agree with some of the stuff that they're saying regarding the pharmaceutical companies and kind of charging and whatnot, but I don't think that remedy for it or the solution for that is cheaper drug prices. That's just me though. That's just me. And I'm not a big person. Like I said, I'm gonna always protect the copyright. The IP owner, which I guess in this case is a drug company, but I don't necessarily kind of rock with drug companies like that just because I know that they can overcharge for things, but I don't think the solution is cheaper prices. Let's move on here. So we're talking next about, and I'm not sure why I have pizza there. Looks like that one didn't get changed, but we're talking about UGG. So it seems like UGG is suing Costco for trade dress infringement of this, I guess it's the Tasman slipper. And I see a ton of people wearing this Tasman slipper. It's not the classic Ultra. I think Kevin Hart had on these. It's the Tasman. And it seems like this is a popular shoe. Every time I see somebody with this style shoe, is an UGG shoe. You see the braid there. And again, I'm going to tell you some of the features of it. Let me see if I can click on this thing. So I'm going to tell you some of the features. The features that they have protected via a trade dress, which is a subset of trademark. And the great thing about a trade dress, much like a trademark, it lasts forever as long as you're using it. But some of the features that they have that they are protecting via a trade. Again, you got to think a trade dress that protects the ornamental look of something. It can't be a functional item. So you can't protect shoestrings of a shoe via a trade dress or a design patent. And design patent and trade dress is similar things, but trade dress is looked at a little bit more, scrutinized a little more because, again, design patents last 15 years, whereas a trade dress lasts forever to the extent that you are using it. And again, to be able to trade dress something, it can't be a functional item. It has to be non-essential. So you can't protect shoestrings because that's an essential and a functional item. It helps kind of secure the shoe to your foot. You can't trade dress an actual shoe, an outer sole, because that's obviously now maybe the pattern on the outer sole, but you can't protect generally the outer sole of a shoe because that's something that is essential to the shoe. So what they have on this particular trade dress protection on this shoe is, number one, they have the braid here around the top portion of it. Let's see if I can go to the next one. You see the seam that's going down the middle. They have that protected via a trade dress. So that seam here, as well as the braid, those are protectable. These are some closer shots of it. Obviously, we know UGG is protected via a trademark. And they said these things are extremely comfortable, man. That sheepskin, that's essentially what the UGG, I think that originated over there in Australia. So you see that seam going down the center of it, as well as that kind of braid around the opening of it. That is big protections of the actual UGG shoe. And can I pull it back up here? So as I kind of pull it back on myself and ignore the pizza, that's for the next segment of the show, or one of the next segment. This shoe to the left here, now the right shoe is the shoe that I just the UGG shoe. The left is the Kirkland signature. They sold by Costco. So Costco essentially is selling a knockoff UGG, and UGG hit them with a cease and desist letter, and eventually UGG hit Costco with a lawsuit or trade dress infringement by selling this, I guess, Kirkland signature shoe that's similar to the UGG. So I think Costco may be in trouble with this one. And again, I'm doing all this, man. This is a learning lesson. Everybody wants to kind of trade off of these big names. We have another one right after this that I'm gonna show you again. And a lot of times, man, I get it. You have this big brand, in this case, UGG. I'm not saying Costco. We all know Costco is a big brand, but you have this kind of big brand with this star product, in this case, the UGG shoe. And a lot of times people want to come in and take kind of market share away from that company without kind of doing the work that company had to do to promote and kind of build up its brand. And again, man, you can try to do that, but I tell you what, people are going to sue you. These companies are going to sue you. They see what you're doing, and they spent millions of dollars, if not billions of dollars, in advertisement, in marketing. They have raked in millions of dollars, if not billions of dollars, in sales. If you think that they are going to let a more or less a knockoff shoe come in a market that's infringing on their IP, you have another thing coming. So again, let me know what you think. To the extent that somebody that got the Kirklands, y'all have to let me know in the comments, man. Are they as comfortable as the UGG? I'm calling it a knockoff. Some people may disagree with me, but it seems like the UGGs are the real deal. And every time I see somebody with that shoe, it is UGG, and they rave on how comfortable those things are. So to the extent that you got the knockoffs, I guess it is what it is. As we move on here, the Snoop loops. I got to play this for you guys. And again, we just talked about it with Costco and Kirkland, the Kirkland signature shoe, trying to trade off of the UGG shoe, the Tasman shoe from UGG. Again, Master P, Snoop Dogg. Look I love y'all, but y'all, it seems like you guys are trying to do the same thing as Costco was trying to do, and trying to trade off Fruit Loops. And Kellogg, which is the owner of the Fruit Loop brand, the Fruit Loop trademark, the Fruit Loop product, was not having it. But before I give you guys my thoughts, let's see what Master P has to say about this. There we go. Let's go.
This cereal out. I don't know if y'all know the story. Kellogg's came at me, went after my trademark. Let me show y'all how the devil work, right? Me and Snoop blew this.
Hey, man, we got to stop saying that. I do want to say that. We got to stop saying it's the devil when you breaking the law. That's like you committing theft, and then you get caught, and the police give you a fine or put you in jail, and you like, this is the devil. No, you are breaking the law. Again, am I like wrong in my thinking? You're breaking the law. If you're taking somebody else intellectual property and using it, and they hit you with a trademark infringement lawsuit, you're breaking the law. Or at least they believe that you're breaking the law, and they're well within their rights. And to the extent that you feel like you're not breaking the law, then kind of fight it in court. But again, I can tell you, Snoop Loops, Fruit Loops, you weren't going to probably get away with that, which kind of brings me to another point. Make sure you you get advice from an attorney before you kind of start doing some stuff like this. But let's go.
This brand up, this company was called Snoop Loops at first. Kellogg said, oh no, take it off the shelf. You're not using it. I had spent millions of dollars. Everything, packaging, all this stuff. I said, you know what? I'm not gonna sell it. I'm gonna feed my people. I went to all these underprivileged communities and gave millions away. That's awesome. And look what God done blessed us with now. Because I started with one cereal, now I have 3. Like he said, when you do the right thing, he'll bless you tenfold. And I didn't give up. And so I needed that. I needed that courage to keep going, even knowing that I lost money. But guess what? That was a minor setback for a major comeback.
So I do definitely agree with them on they keep chugging along through the ups and downs. And I have kind of business owners come on my show every week to talk about the ups and the downs of business and them being able to chuck through, kind of get through it. But yeah, I definitely don't think it was the devil. If you were doing wrong, you were doing wrong. I don't think it was the devil that was kind of trying to kind of block your blessings or whatever the case may be. But shouts out to Master P. It seems like they have 3 cereals now. I'm not sure if the Snoop loop. I didn't see the Snoop loop still being a thing. Look it, if they would have called them things Snoop circles, then I think Kellogg would have been cool with it. But you can't. Again, they have a trademark on the term loops as well as Fruit Loops. So you knew that you were going to get hit with the lawsuit at that point. You can't be surprised over this stuff. Like I said, you have to get counsel. And again, maybe your counsel gave you, let you know what was going on, and you said, okay, I'm gonna still go for it, and you got hit with that lawsuit. And to be honest with you, and I talked about this a little bit more in detail. Go check out that full video that I did. But it seems like they actually tried to file for Master P and Snoop Dogg tried to file for the trademark of Snoop Loops, and the trademark office, which is not associated with Kellogg, they're like, no, we're not going to allow you to register this term of Snoop Loops because you have loops out there that's owned by Kellogg, and it's a likelihood of a confusion, and therefore we're not going to allow you to register your trademark. So really, Kellogg had nothing to do from what I saw of them being able to register the term Snoop Loops because the examiner at the United States Patent and Trademark Office denied that. Now, whether or not Kellogg sent them a separate cease and desist letter and lawsuit saying take those off the shelf as a result of it being similar, maybe that was the case, but I can tell you that, again, you let me know. Like I said, the whole point of trademark law is the likelihood of confusion, and if something is confusingly similar, it's probably trademark infringement. Would you think Snoop Loops and the Kellogg brand Fruit Loops was somehow kind of doing business with each other or similar if you would have kind of rolled up on Snoop Loops? The answer to that question is yes. Trademark infringement is looking likely, and therefore, you're probably in trouble. If the answer to that is no, then you probably have a case. But it seems like that one was going to be a long shot in my opinion. So with that being said, let's move on to the lawsuit breakdown of the week. Solorzanos. And look, let me bring up this website, because I was checking out this website. I actually like these family companies, man. These family companies that are building. And this seems like this was a family company that started in, as you can tell here, it started in Jersey in 1977, Hoboken, Jersey. And now they built this thing up, and now they're in Florida as well. And the thing that I thought was interesting, in which this is actually the reason why they are filed a trademark lawsuit against another company, but it's over this logo. So you see the logo, the dude in the hat with the pizza on it, with the shades on, he has the beard on. What they say, tattoo this logo. It's a trademark logo on your body to join the free Slice for Life Club. So you guys have to let me know, to the extent that somebody's watching this, they have this logo tattooed on them, then let me know how you're enjoying your free pizza for life. The pizza actually looks pretty good, man. As I'm looking at this, the pizza looks delicious. Started in 77, so they've been around for 50 years, almost 50 years. The pizza looks sweet, man. I will say that. The pizza looks really good. But this is actually a trademark logo, which another competitor used, it looks like, and they hit them up, but they sued them for a trademark infringement. We're going to go through that lawsuit here in a second. But I thought this was interesting. Tattoo this logo on your body to join the Free Slice Club. I'm not sure if there's that much free pizza in the world for me to get. But again, people get other stuff, less desirable things tattooed on them. So, hey, to the extent that you wanted to make sure that you will never go hungry again, just get that tattooed, get that logo tattooed on you. I guess you'll never go hungry to the extent that they remain in business, but they've been around for almost 50 years. I think they're going to be around for a while. So let me try to see here. Bring up the lawsuit so we can go through really quick. Let's see what happened in this one, and then I'll get you guys up out of here. So let's pull it up here. This is from Salazar's Pizzeria, and they're suing BBJB Enterprise and Brent Brown. Seems like Brent Brown owns BBGB Enterprise. So let's go here. This is an action of unfair competition and false designation of origin and intersection. I'm not going to read that. Seems like I said, this is the trademark, which we just saw on the website. Plaintiff is a resident of Orlando, Florida. Okay, so it seems like they started in Georgia, and he maybe moved to Florida and took the business with him. So plaintiff Philip is a resident of Orlando. Mr. Salazaro is the owner of the above-mentioned trademark, sole member of the Pizzeria, as well as Salaro's Pizzeria, Sebring LLC. Man, okay, he owns a lot of pizzerias. So Philip is an LLC Pizzeria. I don't care about that. That's interesting. They're formed under the laws of Tennessee. So started in Jersey, currently offering business in Florida, but they are formed under the laws of Tennessee. That's interesting. Seems like the defendant, Brent, is also a Tennessee company. Let's see what they did here. Plaintiffs provide food industry services through their operation of pizzeria in Tennessee and Florida. So they seem like they're no longer in Jersey, just Tennessee and Florida. Plaintiffs has done business at Salazaro's Pizzeria since 2008. Has operated pizza since 2004. The website says they established in 1977. That's interesting. Plaintiffs are the owner of one valid and subsisting USPTO trademark, as well as common law trademarks. The first trademark is registration. This is the logo that we just showed you guys, that to the extent that you get it tattooed on you, you get free pizza for life. Plaintiffs have been using the name Salazaro's Pizzeria in commerce throughout the U.S. continuously since 2008. As a result of this widespread, continuous, and exclusive use of the Filipino mark and Salazaro's Pizzeria mark and the trade name Salazaro's. And let me know if you guys have had the Salazaro's pizza. Is it good? It looks tasty. Plaintiffs' marks are distinctive to both consuming public and the plaintiff's trade. Plaintiffs, on their own and through their licenses and authorized distributors, distribute, provide, advertise, and sell their goods and services under the marks via the following trade channels. So it seems like if you go to that website, which we're not going to go to, you will be able to get more information about the trade channels. The goods and services plaintiffs offer under the marks are of high quality, as evidenced by plaintiff's website and physical store locations. They definitely look like it's pretty good. I will say that. As a result of the plaintiff's expenditures and efforts, the marks have come to signify the high quality of the goods and services designed by the marks, have acquired incalculable distinction, reputation, and goodwill belonging exclusively to the plaintiffs. I never heard of that word, incalculable. As a result of its distinctiveness and widespread use of promotion throughout the U.S., plaintiff marks are famous within the meaning. Okay, seems like they have some famous marks. Let's get to the good stuff. What did the defendant do? Upon information and belief, defendants are engaged in the same or substantially similar business as plaintiffs, namely providing Italian restaurant services and pizzeria services. Plaintiff began operating a pizzeria in Tennessee in 2022, so just 3 years ago. Due to plaintiff's notoriety and success, defendants approached plaintiff regarding business opportunities. Let's do business together. Hey, my mom always told me, man, you can't do business with everybody. Let me see if I can do it this way. This better. I don't know if y'all can see that. My mom always told me you can't do business with everybody. Nonetheless, upon information and belief, the two began business interactions in 2023, so a couple years ago, as evidenced by the 4 separately signed and executed license agreements. So it seemed like it was some licensing agreements. And again, when you have this IP, when you have these trademarks, when you have these patents, to the extent that somebody wants to use them, the proper way to do it is get permission. And a lot of times that permission comes in the form of licensing agreements. The first licensing agreement was signed and executed on January of 23 2023 for a pizzeria in Tennessee. So it seems like the defendants were trying to expand their footprint in Tennessee with these Salazaro's pizzas. The second license agreement was signed just a month later for a pizzeria, again, in another city in Tennessee. The third licensing agreement was to open up another pizzeria in Stonehouse, Tennessee. And then they had their fourth and fifth licensing agreement. Yeah, I don't like this, man. I'm going to tell you why I don't like this. Hey, let's just get the first one up and running. They signed 4 licensing agreements in 1 year for 4 pizzerias in 4 different cities in Tennessee. I don't know how I feel about that. Y'all got to let me know in the chat. I'm more a proponent of, hey, operate the one. Let me see that you can follow the directions with the one. And then to the extent that everything is going well, customers like it, you're abiding by our rules and regulations, then we can open up a second one or maybe a third one. But that may take another year or 2 years. I don't like the fact that they signed 4 license agreements in 1 year. That's just me. Let me know if you guys agree with me or disagree with me in the chat. So they got the fourth one was in Gatlinburg. I ain't never been to Tennessee. Y'all been to Nashville a couple times. Each of the respective licensing agreements in pertinent part granted defendants from plaintiffs a revocable and non-exclusive license for a period of 5 years from the date of opening. Under the, what is that? Severe, man, I'll tell you what, man. Anytime your city got a ville in it, it's an old city. Under one of the license agreements, the defendants agreed to pay plaintiffs starting at the first month of business a $3,000 per month royalty. That's the good thing about licensing. It's typically you have a royalty payment, and $3,500 per month royalty for the remaining 4 years. So the first year they got a discount. Second year they had to pay extra $6,000. And that's actually a deal, because typically when you're dealing with like the big companies, the McDonald's, the Bigby's, the Starbucks, they want you to pay not only a royalty fee, but they want you to pay a portion of the sales, a percentage of the sales, maybe 2, 3, 4% of your gross revenue. They want you to pay to the franchise. So it seems like Salazaro's is trying to essentially kind of start franchising. Under the fourth license, under the Pigeon, another license agreement, the finished purchase for $1.4 million with $200,000 due on signing $100,000 under the Pigeon Forge licensing agreement. So it seems like maybe the owner, the plaintiff, was operating that Pigeon, and they said, look, we're just going to buy it for 1.4. You got to pay us $200,000 at signing. $100,000 is due 1 year after signing, $100,000 due. So essentially they had they financed it. Additionally, under the Pigeon Forge licensing agreement, defendants agreed to pay the plaintiffs a $3,500 royalty fee per month. So they had to pay the 1.4 and kind of pay under that, but they also had to still pay that royalty. Under the Stonehouse, they had that royalty, and under the license agreements, defendants agreed to purchase the non-exclusive training, knowledge, information, and expertise of their plaintiffs. That essentially is pretty standard. Plaintiffs provided training for defendants in order to teach defendants how to operate and run pizzerias, especially using their name. That makes sense. Under the licensing agreement, defendants agreed that the licensing agreements cannot be assigned or transferred to any third party without prior written consent. That's pretty standard. Defendant agreed to refrain from maintaining, operating, or engaging in any business similar to the plaintiff. So that makes sense. Hey, if you are doing business with me, now I'm giving you the option to purchase these, some locations. You're, using my trademarks and my IP to run other locations. You can't essentially be taking all the information that I'm giving you and open up a competing business that's essentially competing against mine. So that's essentially what that paragraph is saying. And they also said that they won't essentially give any trade secrets or anything like that away. Defendants further agreed under the licensing agreements that failure to make any of the required payments would result in defendants being in default. That defendant would be required to cease using the name and knowledge learned under the plaintiffs. Now, typically with those defaults, they allow you to correct them. It's provisions in the contract that will allow you to correct those defaults within a period of time before essentially the contract or the licensing agreements are terminated. Defendants remitted payments as called for under the license agreement until 2024. This is what I'm telling y'all. They signed 4 agreements in 2023. In the following year, as of August in 2024, so what, just last year, they essentially stopped abiding by the agreement. That's what I'm saying. Let's do one. And let's see how this relationship goes for a year, 2 years. If I got somebody and they want to sign 4 agreements all in one, I'm already hesitant as the business owner. What is this person real? Like, what are they really trying to do here? Let's just sign one. Let's see how that goes. Let's, see if, you can abide by the rules of the contract. Let's at least get 2, 3, 4 years into the contract. They didn't even hold up there in the bargain for a year. That's crazy. What mama say? You got to be careful who you're doing business with. So on August of 2024, defendants, Biden through his counsel, sent essentially a cease and desist letter, or seems like sent an erroneous letter of termination of the 2 plaintiffs. So the defendant terminated the contract. Defendant currently operate Italian restaurant and pizzeria services under the name Jersey Hustle Pizzeria. I'm telling you, man. Man, it's a dog world. Look at, man. Do you see what they did? They not only opened up a pizzeria. So, at some point, either this was all the play all along, or somewhere in that first year, they like, man, we can ditch this guy. We can do our own thing. So they said, we're going to cancel the contract. And then we're going to open up our own pizzeria, which is probably in the same area. And they're actually using a similar mark. So they're not only committing trademark infringement, they're committing trade secret infringement. Or misappropriation is what they call it. And it's a dog world, man. A business is a dirty game. Upon information to believe, defendants distribute, provide, market, advertise, promote, offer for sale, and sell under the infringing marks Italian restaurant and pizzeria services, which are the same. Again, obviously they're going to sell a similar product. That was the play all along. Defendants in their marketing and advertising have used plaintiffs' awards and reviews for promotion of their own service. It's a dirty game, man. Let's see here. Is it anything worth what's the name? Upon information, believe defendants manufacture, distribute, provide, market, advertise through the same trade channels. And they're saying it's a likelihood of confusion. Defendant's conversion of 20. Look, they even threw the Mini Cooper in it. In or around July of 2023, plaintiff and defendants entered into an oil agreement. That's your first thing. And look, oil agreements are they can be effective and enforceable, but I'm not doing, unfortunately, man, it's 2025. I'm not doing a handshake with a person I don't know. I would imagine, hey, they just signed 4 agreements. The plaintiff thought they hit a lick. I just sold one restaurant for 1.4. I'm getting essentially what, 3,500 essentially times 4. So I'm getting another 14,000 a month just for this royalty fee. Hey, look, we ride it hot. And then look at this Mini Cooper. We can just handshake on that. We don't even got to sign on that. That's what happened. The plaintiff was feeling real good about this one. So it's in or around July of 2023. They entered into an oil agreement for the sale of a Mini Cooper. I'm assuming that's a car, a minivan. The Mini Cooper agreement called for the defendant Brown to pay plaintiffs roughly $15,000. Yeah, it's a car, so I got the VIN number. So $15,000 for the Mini Cooper. Once full payment was received, title to the vehicle will be turned over to the defendant Brown. So I'm not sure if the defendant Brown had possession of the car or he just had to essentially make all the payments to get not only possession of the car, but also the title, which, seems pretty straightforward to me. Defendant made regular payments under the Mini Cooper agreement until August 2024. So at least he paid on that for a little bit over a year. So he paid $10,000 out of the $15,000. Man, it's crazy, man. Okay, we're going to read through the first count, the first count of trademark infringement. Defendant unauthorized use in commerce of infringing marks as alleged herein is likely to deceive consumers as to the origin, source, sponsorship, or affiliation of the defendant's goods and services and is likely to cause consumer confusion. Defendant's goods and services are sold, authorized, endorsed, or sponsored by plaintiffs, or that defendants are in some way affiliated. Okay, upon information to believe, defendants has committed the forging acts of infringement with full knowledge of plaintiffs' prior rights in the marks and with the willful intent to cause confusion in trade. Okay, so they're not saying anything else, man. So I'm gonna kind of finish up with that. I would love to get your guys' take on this. as Mama said, you cannot do business with everybody. Just to kind of sum this up, the owner, at least according to the website, this was established in Jersey in 1977. Seems like the owner or the plaintiff found himself down in Florida. He seems like he also maybe was running some stuff in Tennessee. Met this guy, Brent Brown. Said, okay, Brent wanted to do business. They signed 4 agreements in 1 year. And he also signed an agreement, an oral agreement, a handshake essentially, on a Mini Cooper for 15 grand. Seems like he at least got 10 grand out of that Mini Cooper. Seems like around a year later, the defendant sent the plaintiff, which you typically don't see that. Typically what you see is, okay, you're infringing our trademark, you're breaching an agreement. The plaintiff is sending some type of termination agreement or termination letter to the defendant. The defendant, Brent Brown, in this case, said, hey, man, we not messing. Even though they signed the 5-year contract, hey, after a year, we don't need y'all no more. We're going to open up a competing restaurant using a confusingly similar mark, therefore committing trademark infringement, allegedly, and selling the same product. Business is a dirty game. Anyway, let me know what you guys think about this when I actually have to run and go jump on this plane here. I got to go jump on this plane. Let me know what you guys think about this. When this airs on Sunday, I am going to try to be in the chat going back and forth with you guys. So let me know what you guys think about it. And we will be back live next week, 7 o'clock Sunday, 7 o'clock Eastern time, 7 p.m. Eastern time. Please hit the like button for the YouTube algorithm. Please hit that subscribe button to be a part of the IP community. And check out the Got IP link in the ebook. And I'm kind of looking at doing some tiers where we're trying to grow the community. We're looking to grow the community, provide even more value. So be on the lookout for that on the community post. We're going to be doing a lot of cool things, bringing in manufacturers, bringing in design people, bringing in business owners, bringing in, there's going to be a lot of people that we're bringing in, marketing people to help you kind of build and kind of take off your brand, take off your product, your services, whatever it is that you're providing. So be on the lookout for that in a community post. And again, see you guys next time.